Good afternoon and welcome to the last in the present series of the Greater China Legal History seminars. My name's Stephen Gallagher. It's my pleasure to welcome you to this latest seminar organised by CUHK Law. Our last seminar, well, it's been worth waiting for our last seminar, of course, because it is being given by our Dean. But before I introduce the Dean, and I'm sure you all know the Dean anyway, but before I do introduce the Dean, let me just say that I'm sure you'll have questions at the end of the seminar, and we're hoping to leave some time for some questions at the end. So please feel free to chat your questions into me, and I'll try and ask those at the end of the seminar to Professor Wolff. So let me introduce the last speaker in the present series. Professor Lutz-Christian Wolff is the Wai Lun Professor of Law and Dean of the Faculty of Law at the Chinese University of Hong Kong. Professor Wolff spent several years of studying, doing research and working in a number of different jurisdictions, including, of course, the United States, China, and of course, Germany, before he came to Hong Kong. He's been based in Hong Kong since 1999, and of course, he was one of the founding members of CUHK Law. Professor Wolff specializes in Chinese and international business law, private international law, and comparative law. And of course, he has a number of works, a number of books, which he has published, either authored alone or edited collections as well, and also many articles in international law journals as well. Today, Professor Wolff is going to be talking to us about the development of investment law in China. So now I'll hand over to Professor Wolff. Lutz.
Thank you, Steve. And many thanks for everybody to joining today. Special welcome, of course, to my IBT2 students. Good to see you all here. Let me share my PowerPoints. I hope I can do this. All clear? Good. Thank you very much again. My topic today is the development of China's inbound investment law. And this, of course, relates to the development since 1979, since the start of the reform process. I plan to divide my talk into two parts. First, I will report on some milestone legislation in the area of China's investment law, mainly relating to investment vehicles, government control, M&A, merger control, national security review, and then I will talk, of course, also about the new PRC Foreign Investment Law. And then during the second part, I will try to analyze these developments. I will see whether we are able to identify common drivers, whether this will then lead to patterns, and whether this will allow us to predict the future, to make some predictions regarding future developments. Before I start, I wish to acknowledge research support provided by Dr. Channy Chen, who helped to dig out some of the data I'm going to present today. And I would also like to make, before starting, 2 points up front. First, as I've mentioned, I will discuss the development since 1979. That was the time when the reform process started. No need to mention that in 1949, the People's Republic of China was established and then moved into a long period of self-isolation from the rest of the world. The disaster of the Cultural Revolution struck from 1966 to 76, and what followed was a power struggle between different fractions, and the reformers led by legendary Deng Xiaoping and his supporters, of course, won. And that was the basis for the start of the reform process, which was marked by the famous decision of the Central Committee of the Communist Party of China at its third plenum to reform the agricultural system in December 1978. The reforms actually took off. They started in 1979. And what we need to remember is that in those days and throughout the 1980s, and even during the first half of the 1990s, China's situation was really very basic. China came from zero, and we should not forget this. You have a photo here from Shanghai in 1983. The photo was taken right next to Nanjing Road, and we can see how underdeveloped it was compared to what we have now. Foreigners, there was self-isolation since the revolution until 1979, and foreigners were still not a common feature in China in those days. Even in 1983, when I was studying at Fudan University in Shanghai, a foreigner could basically draw huge crowds, even in places like Shanghai, not to talk about the countryside. I mentioned the power struggles. In fact, for quite some time, it was unclear if the reform process would be able to go ahead and how it would and should continue. And this, of course, also affected the development of China's investment law system. In other words, this was not a straightforward matter, which followed a clear plan on the basis of a coherent strategy. I will get back to that point later in the last part of my presentation. The second point I want to make is that today I'm talking about inbound investment law. The controlled development of China's foreign investment regime stood at the heart of China's economic reforms since 1979. And the focus of these developments were in the 1980s and 1990s on inbound investments. In contrast, outbound investments from China to the rest of the world did not really play a major role until the end of the last century. That has, of course, changed starting from the beginning of the new millennium. The picture changed dramatically, and regulatory activities regarding Chinese outbound investments have consequently become increasingly important. But that's not my topic for today, simply due to time constraints. To set the scene, let's have a quick look at numbers, the development of China's outbound investment volume. As you can see, in 1979, there was basically nothing, but this changed quickly. And in 1984, China's inbound investment volume reached a size of more than $1 billion for the first time. And of course, the development continued, peaked in 2013, and Chinese inbound investments did in fact play a major role in the developments in the Chinese reforms. Now, let me now turn to legislative developments. As mentioned, I wish to trace milestone legislative developments in core investment law sub-areas to remind us how things have developed. I will start with investment vehicles. Investment vehicles, in every jurisdiction, investment vehicles must take particular forms which serve to carry the investments, which serve as the legal form of investment projects. And available investment vehicles differ from jurisdiction to jurisdiction, and they carry certain advantages depending on who looks at them. In particular, investors, of course, need to consider carefully which investment vehicle is most suitable. It was a defining feature of China's investment law system for a very long time that investors had to use dedicated investment vehicles, which are normally called foreign investment enterprises or foreign invested enterprises, FIEs. You can see on this chart the main FIE types, most importantly, equity joint ventures, cooperative joint ventures, wholly foreign-owned enterprises. And then it was also possible to establish rep offices, branches, to invest in joint stock companies or foreign invested partnership enterprises. I will focus today, because there are lots of other topics to be covered, on the first three types: EJVs, CJVs, and Wolffs. Foreign inbound investments were first allowed in China in the form of so-called equity joint ventures under the PRC Sino-Foreign Equity Joint Venture Law, which entered into force as early as in July 1979. this EJV law was supplemented by implementing rules in 1983, and later by numerous rules and regulations on all sorts of specific topics: minimum capitalization, the ratio between investments in kind and in cash, tax, labor issues, and so on. EJVs were established jointly by at least one Chinese party and one foreign party. They were established as limited liability companies to pursue a particular scope of business. And the partners, of course, had to make capital contributions in cash or in kind. And it was one of the defining characteristics of EJVs that the profit distribution and the appointment of directors the highest EJV board and at the board of directors had to be strictly according to the equity ratio of the equity joint venture partners. Now, the establishment of the EJV framework as early as 1979, that is immediately after the decision that China would start the reform process, was of course motivated by the need to bring in foreign technology and to get access to hard currency. The legal framework for EJVs has always been quite comprehensive and tight. Nevertheless, EJVs were for a very long time the most important and most popular investment vehicle. And that was not least because the authorities were very familiar with this investment vehicle type. The first EJV was the joint venture between Beijing Air Catering and the Civil Aviation Administration of China, CAAC. The father of famous Annie Wu Sok Ching, her nickname was Miss 001. Her father and his partners invested 5 million Hong Kong dollars in this project. According to Annie Wu, about 5 months after the first discussions, the Director General of CAAC approached her father and asked if the money could be made available right away because the approval by Deng Xiaoping would still require some time. And the investors agreed on the basis of a handshake, and they started to set up the operation without the necessary approval. The approval was granted eventually in March 1980, and the joint venture was officially opened on the 1st of May 1980 and started its business with a Pan Am flight directly to Beijing. And Annie Wu commented on this whole development. So in China, we always think it should be that this is the way to do business. Have the egg before you have the mother hen. Another famous early years EJV is, of course, the White Swan Hotel on Charmian Island in Guangzhou. According to anecdotal evidence, the State Council had set up a committee to attract overseas investment in hotels shortly before the December 78 decision of the third plenum. The committee's task was to build altogether 8 joint venture 5-star hotels in Beijing, Shanghai, Nanjing, and in Guangzhou. And apparently Henry Fok Ying-tong, the legendary Hong Kong tycoon who unfortunately passed away in 2008, was approached by the Hong Kong Xinhua News Agency, which in those days, of course, was the de facto representation of the central government in Hong Kong. And Henry Fok agreed to the deal. The deal was signed in 1979, and the White Swan Hotel became the first joint venture hotel in China. Many international leaders have stayed there. Queen Elizabeth, Richard Nixon, George H.W. Bush, and it was an equity joint venture, the form that was taken for this investment. So EJVs were really important in the past. With the enactment of the PRC Foreign Investment Law as of the 1st of January 2020, which I will discuss later, EJVs are no longer available as investment vehicles. Now, during the 1980s, investors normally from Hong Kong and Taiwan, they didn't like that rigid framework for EJVs. And they started establishing joint ventures which expressly were not based on the EJV framework, but rather on a contract signed between the joint venture partners, for which reason this joint venture type was also often called contractual joint ventures. PRC legislators reacted to this development by enacting the PRC Sino-Foreign Cooperative Joint Venture Law in 1988, supplemented by implementing rules in 1995. The establishment of this CJV framework legalized the existing practice and at the same time forced, of course, the existing practice into a framework and thus under government control. But in line with previous practice, the CJV framework still allowed for more flexible joint venture features as compared with EJVs. Like for EJVs, the CJV law was also abolished with the enactment of the PRC Foreign Investment Law in 2020. And like EJVs, CJVs need to be brought in line, the existing EJVs and CJVs need to be brought in line with the PRC company law within 5 years' time. Wholly foreign-owned enterprises, WOFIs. As the name suggests, WOFIs are investment vehicles established by one or more foreign investors without the participation of Chinese partners. And when the Chinese market was not yet very transparent during the 1980s, early 1990s, foreign partners normally opt to rely on a joint venture partner, opted for a joint venture, EJV or CJV form. WOFIs were mostly used by investors from Hong Kong and Taiwan with existing relationships in mainland China, with existing connections in mainland China. Now, with the development of China's economy and an increasing transparency of the Chinese market and more experience also gained by foreign investors, WOFIs became more popular and later even the most popular investment vehicle in China for foreign investors. The assumption that most of the problems related to investments in China that foreign investors encountered were a result of an unhappy relationship with foreigners and Chinese partners also reinforced this trend towards WOFIs. Now, China has traditionally controlled WOFIs rather tightly. And that meant that the establishment operation and termination was much less flexible than for EJVs and CJVs. In particular, the permitted scope of business for WOFIs was rather restricted and they were not allowed in many regulated industries. China was forced to remove these restrictions upon its accession to the WTO in 2001. I'll get back to that later on. Like EJVs and CJVs, also WOFIs are no longer available since 2020, and existing WOFIs need to be transformed into one of the forms offered by the PRC company law within 5 years' time from 2020. I mentioned earlier that it is possible to establish also rep offices, branches, joint stock companies, foreign invested partnership enterprises, but I don't really want to discuss these further. I rather want to focus on other topics. Next, government control. So government control. Government control in line with the trend in the 1970s and 80s worldwide. Since the start of the reform process, China has always restricted foreign inbound investments in various forms to protect domestic interests. For example, I've just mentioned the different investment vehicle types, which are my charts visible? Can you see them? Okay, good. Foreign investors had to use dedicated investment vehicles, and foreign investment projects also had, whether established in the form of greenfield projects or in the form of M&A transaction, have always been subject to government approval, registration, and verification requirements. As a matter of principle, MOFCOM, previously MOFTEC, the Ministry of Commerce, or its local organs were in charge of approving all inbound investment projects. The competence of the different MOFCOM agencies, branches, was determined by the size of the project, by the industry the project was placed in, and other factors. The approval of other government organs, such as the China Securities Regulatory Commission, CSRC, for acquisitions of listed companies, and the State-Owned Assets Supervision and Administration Commission for the acquisition of assets or equity interests in state-owned enterprises, or other industry-related bodies, was sometimes always also required. And in practice, it was really rather difficult to determine if a project was approvable and which authorities were in charge to approve a particular project. Foreign investment projects also had to be registered with the State Administration of Industry and Commerce, which in 2018 became part of the State Administration of Market Regulation. And in addition to that, on the basis of provisions enacted in 2004, also verification was required by the National Development and Reform Commission, which checked whether the project was in line with the overall industrial development planning. Now, in the early days of China's investment law history, the approval and registration of foreign investments seemed to be at the discretion of the authorities. And it was one of the main challenges, of course, of investors and their advisors to find out which project was approvable and which was not. More clarity was gained in 1995, which led when the tentative rules on guiding foreign investment orientation were published. Later, they were replaced with a different set of rules in 2002 and two national level catalogs. And this framework categorized investment projects in 4 categories: encouraged, permitted, restricted, and prohibited. It was always uncertain whether Chinese authorities actually had a duty to approve or register projects which met all the formal requirements. And it was even more uncertain whether it was possible to enforce the approval in court. Now, in 2013, China then started to experiment with the so-called negative list approach. Under this approach, projects which are not mentioned in a so-called negative list are treated like domestic investments and do not require special approval. In contrast, those negative listed projects are either forbidden or they are restricted. In other words, rather than being per se subject to an approval requirement, foreign investment projects were now prima facie allowed unless they were in those negative listed areas. The negative list approach was adopted countrywide in 2016, and the former approval system was replaced with a filing system. And this was a major development to which I will refer later. Here you have the object of desire of all foreign investors and an anonymized copy of a joint venture approval certificate and a joint venture business license. This, of course, was something everybody was aiming at. Now, before I continue to discuss the key milestone developments with a focus on M&A legislation, just a quick word about researching Chinese law in those early days. Nowadays, everything is easy. You have databases which can be accessed online. A lot is available online anyway. There's transparency, but that was not the case in the 1980s and the 1990s. Remember, there was not even internet at those days. And first in 1980, there was not much written law anyway, and there was also not much legal practice you could rely on, not much precedent. And So what it did was collect whatever information one could get, newspaper articles, books, other materials, pamphlets, manuscripts, but again, detailed and really helpful secondary sources were really rare and hard to come by. And some of the materials, of course, were also published as NEBU materials, only for internal use, and certainly not for foreigners. So getting informative primary or secondary sources was difficult, and in practice, investment lawyering was learning by doing. In the 1990s, the situation then got out of control because on a daily basis, you had rules and numerous rules and regulations almost published, and these documents and these rules were published at different levels by different authorities in relation to different subsystems, in relation to different areas, leading to a degree, to a level of complexity, which even experts in the field had difficulty to understand. And of course, many of these rules were conflicting, they were overlapping, and there were still unregulated areas. So it was lawyering in those days was, investment lawyering was first of all trying to find out what the law actually was, and then you could move forward. The old China hands joining today will get nostalgic feelings, I think, when looking at these photos of old China law materials, which we all cherished in the 1980s. This set of books was sold in the friendship stores, which existed in those days, where you could only pay with the special foreign currency. There was even a law dictionary and a civil law book. But let me return to the milestone. Before I get too excited, let me return to milestone legislation. China's M&A market is relatively young, and so is the legal framework supporting inbound M&A transactions. In fact, China's investment system was originally built on the greenfield model. That is the idea that investors create investment projects from scratch, rather than buying into or merge with existing Chinese enterprises. And as a result, detailed rules governing inbound M&As did not exist until the late 1990s. But when China's economic reforms took off, the need for M&A option, of course, and supporting legislation, of course, became apparent, and perceived control needs, as they existed in relation to greenfield investments, of course, also applied for the emerging M&A market. So inbound investments via the M&A route were therefore initially also made subject to strict government approval and registration requirements. The establishment of China's M&A system started in 1997 with the enactment of a set of rules which carries a rather strange name: changes in equity interest of investors in foreign invested enterprises, several provisions which covered, amongst others, the transfer of equity interest in FIEs, in foreign investment enterprises, from one investor to another investor, from one investor to a third party, and also transfers of FIE equity interest as a result of a merger or division of the original investor. Now, these provisions did not address the acquisition of equity interest in purely domestic enterprise, and they did not cover asset deals. That was addressed in 2003 with the enactment of the acquisition of domestic enterprise by foreign investors tentative provisions. And of course, supplementing the emerging M&A framework were rules that were enacted since 1998 onwards on the use of foreign investments as part of the ongoing SOE reforms. Already in 1999, the merger and division of foreign invested enterprise provisions had entered into force, which, as the name suggests, covered mergers and divisions of FIE, it was foreign invested enterprises. 2006 also saw the enactment of an updated version of the PRC company law, which now had a chapter on the transfer of shares of equity interest, and provisions regarding companies limited by shares were also updated. And as in other areas, these basic rules were supplemented by numerous rules on specific topics such as industry-related issues, taxation, asset valuation, or foreign exchange control. The developments starting from a decade ago have also brought major changes to the M&A framework, as I will discuss later. Next topic, national security review. National security review is review systems enable governments to screen foreign inbound investments and to veto or put conditions on these investment projects in case of national security concerns. Around the world, national security review systems have become very important over the past 2 decades. There's a whole area emerging here, which was previously could previously be ignored, but it's becoming very important. And in particular scenarios, the government authorities have blocked Chinese investments in the US, in Canada, in Australia, and in Europe have received global attention. Like many other countries, in China, the national security review is a rather new phenomenon. But it must be remembered in this regard, of course, that China had approval and registration requirements in place since 1979. And these requirements of this approval process and the verification process, of course, allowed authorities to veto foreign inbound investments or to impose restrictions. And this offered, and as far as negative listed projects are concerned, still offers, continues to offer the opportunity to address also national security concerns, at least de facto. Now, starting from the new millennium, incomplete and impractical national security review rules, which caused much concern amongst foreign investors and their advisors, had been enacted in China. They were very, very basic, really, and actually not practical, and they were never really enforced. But of course, when you see such a rule popping up, you get concerned that now investments are coming under tight scrutiny, which in those days, as I mentioned, could have actually be done through other mechanisms. Based on Article 35 of the PRC Foreign Investment Law, then on the 19th of December 2020, the NDRC and MOFCOM jointly published the measures for security review of foreign investments. It's noteworthy, and that creates a comprehensive national security review framework. It's noteworthy that compared with the former regime, according to these measures now, also greenfield investments and not just acquisitions are subject to a national security review. A national security review is required if foreign investments are made in particular areas. First of all, in anything that is related to the military industry, manufacturing, building of facilities, equipment, services, etc. And then also, if the investment is in key areas with national security relevance, relating to agricultural products, relating to IT, internet, energy and resources, cultural products, and so on. And national security review is required here if control of a foreign investor is over that enterprise can be attained. Again, the establishment and refinement of China's national security review system mirrors developments in other countries. In the US, we have the Foreign Investment Risk Review Modernization Act of 2018 has enlarged the scope, the jurisdiction of the Committee on Foreign Investment in the US, CFI-US. In the EU, Regulation 452 out of 2019 introduced a framework regulation on foreign direct investment. And of course, within the EU, many of the EU countries have their own national security review system. In the UK, in November 2020, the government announced the National Security and Investment Bill, which introduced a standalone CFI-US style foreign investment regime, which has become law on the 4th of January 2022 in the form of the National Security and Investment Act. Merger control. Merger control aims to restrict or prohibit transactions with a negative impact, roughly speaking, on the market. In China, the basic rules regarding merger control are set out in one chapter of the PRC anti-monopoly law, which entered into force in 2008. But it's interesting to note that even as early as in 1985, the Legislative Affairs Bureau of the State Council had established a committee to draft a comprehensive anti-monopoly law, which, however, due to different opinions on particular aspects, never succeeded in coming up with a system. There are notification requirements under the the existing merger control system. The chapter in the PRC anti-monopoly law is supplemented by numerous implementing rules, and those who are in the area know that from 2008 there was a steep learning curve in applying the merger control rules and adding on different rules and regulations to make this a comprehensive and functioning and reliable system. It has always been speculated if China's merger control regime could be, and in fact would be, used for protectionist purposes to reintroduce rules, restrictions which had been removed, for example, as a result of China's accession to the WTO. And as I said, the speculation was whether merger control rules would be used for protectionist purposes. There is no hard evidence, I think, still until today, that this was ever the intention or that this has ever happened, although foreign investors have been subject to a much larger number, in much larger numbers to merger control proceedings as compared to purely domestic transactions or companies. Having said that, foreign investment projects are particularly prone to merger control scrutiny for two reasons, of course. First, foreign investors may already have a substantial market, may dominate a specific market. They may have a very dominating market position because of advanced technologies, which they may or may not have introduced to the Chinese FIEs in which they have invested. And second, if you make investments, of course, you make investments in companies with potential, and they may have a very strong market position already, so that if you invest in them, then the merger control rules are triggered. I'll stop my brief review of these milestone developments here. Let me summarize my short survey as follows. It was really always one of the main problems of China's investment law system that it was not set up as a coherent system based on a strategy, on a plan. It was rather comprised scattered rules and accountable laws and regulations which were enacted at different times for different purposes by different authorities whenever ad hoc need had arisen. There were, my short review hopefully has shown that there was really a great variety of different subsystems depending on factors such as investor type, industry, investment mode, and apart from the fact that many investment law rules were partly unclear in the early days in particular, their respective scope was overlapping and sometimes even contradicting, as I've mentioned earlier. And then there were, of course, different authorities in charge of applying and interpreting and controlling these subsystems. And then China's tight control of foreign investments was, of course, a point of a lot of criticism, while Chinese companies starting from the new millennium seem to have free access to foreign market. And this was a point of a lot of criticism, particularly after China's outbound investments have taken off in the last 2 decades. Now, on the 1st of January 2020, the PRC Foreign Investment Law has entered into force, and that was a major step forward. The law creates a new uniform basis for all foreign inbound investments in China, and therefore one can say completes the process of setting up an investment system in China by consolidating the previously existing subsystems to a certain extent at least. The law underlines the principle of equal treatment of domestic and foreign investment projects and foreign and domestic investors, and that is something which everybody was looking for. MOFCOM had published the first draft of the PRC Foreign Investment Law in 2015, and that has immediately sparked a wide discussion in China and outside China. It was really a lot. There was really a lot of discussion. The second draft was then published in 2018, but it took almost 5 years until after the first draft was published, that the PRC Foreign Investment Law finally entered into force. The PRC Foreign Investment Law is supplemented by a number of other rules and laws, and again has now which now form a consolidated investment law system, which does away with some, at least, of the subsystems. Except for negative listed areas, I've mentioned that now the PRC Foreign Investment Law grants foreign investors national treatment, same market access like domestic investors. The PRC Foreign Investment Law emphasizes that China must ensure participation and fair and equal treatment of FIEs in government procurement projects, an area that has also led to a lot of criticism in the past. And in fact, China has published, amongst other things, in 2021, policies on granting equal treatment to domestic and foreign businesses in government procurement activities. That was published by the PRC Ministry of Finance, but has apparently not impressed the EU, which has just brought legislation on its way which aims to add reciprocal market access, and I quote from the Financial Times, in countries like China. A whole chapter 3 of this new PRC Foreign Investment Law addresses the issue of investor protection and confirms that expropriation may only be is only allowed if there is done for public purpose in line with legally prescribed procedures and against prompt, fair and reasonable compensation. As a matter of principle, foreign investments are no longer subject to an approval requirement, but must be recorded with the SAMR. But there could be still industry-related licensing requirements. What is important is, and I've mentioned that a couple of times already, that the FIEs, foreign invested enterprises, must follow the forms offered by the PRC company law. And that means that the EJV, CJV, and WFI regime are abundant. And the existing EJVs, CJVs, and WFIs must be brought in line with the PRC company law within 5 years from 2020. I've mentioned that the PRC foreign investment law is a major step forward, but of course it has not solved all the problems in China's inbound investment law system. Many issues are still need to be clarified, and there are many government authorities working on this. And this concludes my short survey of the legislation or the legislative developments in the PRC investment law area. And I would like to move forward with my analysis of what has happened and whether we can identify any drivers and patterns. But before I want to do this, I want to remind ourselves that all this has happened in a period of only 40 years. China really came out from zero in 1979 and had to rebuild the whole country. And a lot of ad hoc action and improvisation was required in this regard. And it's not surprising that the whole process, of course, did not happen overnight. It did not happen without hiccups, uncertainties, and practical problems. I wanted to share with you one story which I had already told on a different occasion a couple of years ago, to show that things were really a bit basic in those years. I was working on my first PhD thesis at Beijing University in winter 1988 to 89, and it was one of those very cold Beijing winter days with -15 to -20 degrees, when I was riding my bike from Beidar all the way to Wangfujing to watch a play at the Capitol Theater with a Chinese friend in the city center. The friend, who later became a very famous government official, a high-ranking government official, also came by bike, but he was a bit late. And when he arrived, I asked him if he did not also feel terribly cold. This is another photo from Beijing, north of the Forbidden City. Of course, in those days, you could still ice skate there. So I asked my friend whether he felt whether he also felt very cold, and he said, "No. See this?" And then he opened his jacket, and underneath he beat his chest, and he had one of those woolen sweaters, as we were all wearing them in those days, and pulled it up and showed me there was a pile of paper underneath, and he said with a bit of pride, "This keeps me warm." And I looked at him and asked, "What is it?" And he gave me a big smile and said, "It's the blueprint for the establishment of China's stock market system." And it turned out that he had just been to a meeting with members of the State Council where he had presented his proposal. And this friend has in fact been instrumental in establishing the Chinese securities system and the Chinese stock markets later on. Okay, back to the analysis. Let me try to see how we can make sense of the development of China's investment law system. What were the drivers? Are there any patterns? And if there are any patterns, can they help us to predict how China's investment law system will develop in the future? First, the evolution, the development of China's investment law system must, of course, be considered in the context of the political and economic reforms that took place since 1978, since 1979. These reforms were a state-led, leadership-driven, top-down political process in which a determined political leadership partly bypassed and partly restructured a largely reluctant and resistant bureaucracy under constant pressure from an increasingly globalized international system. Quote from Feng Hui, The Politics of China Accession to the WTO, second edition, published in 2019, a good book. At the start, these reforms consisted of two main elements. First, they involved a change from a planned economy to what has later been labeled a socialist market economy with Chinese characteristics. Second, after 30 years of self-isolation since the revolution in 1949, the reform also implied, of course, an opening up of China to the rest of the world. And this included integration into international trade, investment and financial systems, and arguably culminated in with China's accession to the WTO in 2001. Now, the establishment and further development of China's legal system, including, of course, the development and the establishment and development of China's investment law system, was a significant part of this whole process. It's important, again, that the building of legal structures to support the ongoing reforms from scratch was really an extremely difficult task, a challenging task. And this was not least the case because there was no related know-how in China. There were no legislators or lawyers who knew how to set up tax systems, how to draft rules, and so on. It's also important in this regard that since the beginning of the reform process, Chinese lawmakers had to deal with a dilemma. On the one hand, they had to pursue the goal to establish a modern and open investment law system, while on the other hand, they had to attempt to keep inbound investments under control and to take corrective measures where this was required. And to when things moved into an undesired direction. I'll get back to this in a minute. In other words, inbound investment lawmaking, inbound investment-related legislative activities had to pursue two contradicting goals. And it's very interesting to note that a similar situation has emerged in many countries over the last decade, or the last 15 years probably, after the global financial crisis. In 2010, the United Nations Conference on Trade and Development concluded that, I quote, dichotomy in investment policy trends is emerging. It is characterized by simultaneous moves to further investment liberalization and promotion on the one hand, and to increase investment regulation in pursuit of public policy objectives on the other hand. But back to China. The development of China's investment law system can be divided into broadly three stages. In the initial stage, during the 1980s and the 1990s, China had to establish a stable and reliable system to attract foreign inbound investments with the goal to ensure, I've mentioned that earlier, access to hard currency and foreign technology, advanced technology. And that was, of course, to drive the reform process. Remember, these were times when China's future was still uncertain. I mentioned those political struggles in late 1970s, early 1990s. What you see here is a photo taken in 1983 on Fudan campus when, as of a sudden, slogans from the Cultural Revolution reappeared. In the 1980s, living conditions in China were still rough, almost everywhere, even in the main cities. Shanghai saw snow for 2 weeks, but this is a photo from Fudan again, But of course, south of the Yangtze River, there was no heating allowed anywhere, and it got quite cold inside. The second stage of China's investment legislation took place from the year 2000 to 2010. With the start of the new millennium, the Chinese economy had become, in fact, more mature, more sophisticated, and more transparent. And during this period, the number of domestic enterprises, which became strong and stronger and became serious competitors of the FIEs, saw a steady increase. Then, after the global financial crisis of 2008-2009, China's economy grew stronger and stronger and stronger, and rising consumer prices and labor costs, as well as increasing restrictions imposed by environmental laws in China, led to a situation where inbound investment were no longer attractive just because they were cheap, because production costs, operation costs were cheap. FDI therefore had to be redirected towards domestic demand. Foreign investors did no longer focus on manufacturing, while technology, IT services, aerospace, transportation, financial services became more important. In addition, the gap between the very well developed areas along China's eastern coast and the less developed areas in China's central and western regions required, of course, action on the part of the Chinese government. And as a result, a shift of China's investment policy could be observed towards the goal to attract high-tech investments and to redirect investments towards the east and the central and western parts of China. It's also important that at the beginning of the second stage, China finally succeeded in becoming member of the WTO, with major consequences, as I will discuss later. The third stage of building China's investment law system was, I believe, the stage where there was work done towards the enactment of the new PRC Foreign Investment Law and a consolidation of the previously existing multiple subsystems. Now, is it possible to identify drivers, common drivers of China, of investment legislation in China? Are there reasons, are there similar reasons that can be identified which are valid across the board? The development of China's economy since '79 has been nothing but breathtaking, with often double-digit growth rates and similar impressive inbound investment volumes. Inbound investments, I've mentioned that many times, were really important for the entire reform process. I've tried to highlight that. And one might therefore speculate that investment-related legislative activities in China were at least sometimes driven by a fluctuation of China's inbound investment volume. This chart shows very interesting numbers. However, according to my assessment, it's very difficult to draw firm conclusions regarding the relationship of China's inbound investment volume and particular legislative developments in this investment law area. For example, the negative development of China's inbound investment volume during the period from 1998 to 2001 came at a time when China was about, I've mentioned that earlier, to set up its M&A framework, with the goal, of course, to facilitate inbound investment through the M&A route. The enactment of these rules, however, had started earlier in 1997 with the changes in equity interest of investors in foreign invested enterprises, several provisions, and considering the necessary lead time, could not have triggered the could not have been triggered by a declining inbound investment volume. Legislative developments in other periods, I think, can similarly, or can as well hardly be linked to particular legislative projects. Of course, it would be nothing but surprising if Chinese leaders had not monitored the inbound investment volume and if they had not considered legislative action in the case of unwanted developments up or down. But again, I really think it's difficult to establish direct links to the enactment of specific investment laws and regulations. Foreign investors, their legal advisors, their home countries, their representative organizations at national and international levels are of course major stakeholders in China's investment law system. And these stakeholders have always tried to influence the development of China's investment law system in different ways. It can be safely assumed that many of these expressed views were noticed, even when they were not directly addressed to lawmakers. They were noticed, considered, and action was taken when it was felt that there was something that was important. International impact of China's foreign investment laws on China's investment law system is, of course, most visible in the context of China's accession to the WTO. The late 1990s were dominated by negotiations over China's accession to the World Trade Organization. The Chinese Communist Party's authority became subject to international scrutiny. The reformist fraction of the CCP, led by Jiang Zemin and Zhou Rongji, saw the WTO as an opportunity for future reform and rallied to attract foreign investors, carefully retaining Deng Xiaoping's vision of socialism with Chinese characteristics, and Chinese regulations evolved in response to this new political reality, quote from Deschmuck and Bafna. As a result of China's WTO accession in 2001, in particular, the WFI regime was significantly liberalized, and WFIs became available as investment vehicles in many previously regulated industry sectors where WFIs could previously not be established, or where it was only possible to invest in these areas in the form of joint ventures. China's WTO accession therefore had really a direct impact on the development of China's inbound investment law system. And it has also increased the China's attractiveness for foreign investors, for foreign investments, and it has boosted foreign confidence in the Chinese reform. You have some numbers here. China's industrial output generated by FIEs grew from 28% before China's WTO accession to 36% in 2003. How about other historic events? A lot, of course, has happened since 1979. The Asian financial crisis, we had the handover of Hong Kong, Macau, the global financial crisis, the Euro debt crisis, Xi Jinping assumes presidency, and of course the BRI was announced in 2013 and started in 2015. While Chinese lawmakers have certainly, I believe, taken note or even expected these developments, there's again no clear evidence that they have directly influenced the process of consolidation and liberalization of the Chinese investment law system over the last decade. Now, as I had mentioned earlier, the development of China's investment law system was not a straightforward process for a number of reasons. The leadership took corrective steps when developments were regarded as not desirable or as moving into the wrong direction. I've mentioned earlier the reasons how the CJV and Wolff framework was established, the framework, the establishment of the Wolff system and the CJV system was a reaction to factual developments, and with the enactment of these laws, rules, and regulations, these new investment project types were forced into a legislative framework and thus brought under government control. It is interesting, however, that China did not always revert to legal action or tools immediately prescribed by formal laws and regulations to remedy unwelcome situations. As another example shows, round tripping. In 2005, Chinese authorities put in place new cross-border currency control, transfer control, and restrictions, and that was done in order to control or to bring so-called round-trip structures under control. Round-trip structures work very briefly like this. As shown on this chart, the traditional form of investing in China is a direct one. So they have a foreign investor sitting in a home country, and that investor invests in mainland China by establishment of an EJV or CJV or a Wolff. This direct investment structure has certain disadvantages, or had certain disadvantages. For example, and these disadvantages are a result of the restrictions enacted or in place onshore. For example, if a foreign investor wanted to dispose of its joint venture portion in China, under the original rules, the consent of the local investor was required and government approval was required, and there were other preconditions which I don't want to list out here. So if the local investor said no, in the beginning, you couldn't do anything. If approval was not granted without reasons, there was nothing you could do. And that while eventually legislation was brought underway to remedy the situation and say, you know, you have to approve or you have to consent, otherwise there are other remedies. This was troublesome and did not allow the investor to dispose of investments as they wished. There was no flexibility. Similar restrictions existed in relation to financing, onshore financing, debt financing or equity financing was limited, and in particular IPOs were not possible, going public was not possible for FIEs. So what foreign investors did, they used offshore holding structures. Offshore holding structures work as follows. You set up an SPV, a special purpose vehicle, outside China, which would then act as a holding for the onshore investment. So the investor would set up a company, say a co-limited in Hong Kong, which would then invest, set up a joint venture together with a Chinese partner in China, or it would invest by setting up a Wolff onshore. That has certain advantages. As mentioned, it offers offshore flexibility because you can now transfer the SPV shares, and this would not be subject to mainland Chinese law. You would get access to offshore financing, and there were also restrictions on SPV, the use of SPV shares as security. So you could now use the FIE shares as security. So you could use the SPV shares as security. SPV structures are internationally, of course, normally used for tax reasons, although this has come under scrutiny and attack in recent years. But that was not the main reason for China inbound investments to use SPV structures. The SPV would also allow for a secrecy, to gain secrecy, to gain confidentiality, because if you had SPV structures one after another, then in the end it was difficult to find out who was the ultimate investor was. it would also provide an additional corporate bail and lead to BIT, would allow BIT shopping, treaty shopping. Chinese investors also used SPV structures, and they did this for the round tripping that I had mentioned earlier. Originally, this was done for tax reasons. Chinese investors, natural persons normally, would set up an SPV outside China, would reinvest in China, thus artificially creating foreign investment enterprises, which would, until 2008, be eligible for certain tax holidays. Until 2008, China had in place a tax regime which offered special tax rates for foreign invested enterprises for the first 5 years if certain conditions were met. So a Chinese investor could take advantage of these special tax rates by investing out and investing in again. After 2008, there were other reasons for Chinese investors to use these SPV structures. Amongst others, they were used to fraudulently dispose of Chinese state-owned assets. So what happened was that this Chinese investor, a natural person, set up, say, a Wolff in China, and then arranged for state-owned assets to be sold to this Wolff, of course, below market price. And the Chinese investor would then sell the SPV share, SPV2, to a foreign investor, a PE fund or another investor. And that made the investor happy because the investor would get, via the SPV, equity interest in the Wolff, which had these valuable assets. And the Chinese investor was happy because it would get the purchase price from the foreign investor who took over the SPV shares. The only party that lost out was the Chinese state. And that, of course, triggered the nerves, and the Chinese authorities took action. According to anecdotal evidence, even before proper legal transparency rules and other rules were put in place to remedy this unwelcome situation, banks stopped processing cross-border capital transfers for the time being, and have therefore de facto blocked inbound and outbound investment. As a consequence of the whole situation, many investment projects were brought to a stop, and the year 2005 even saw a decline of China's overall inbound investment volume. So that was another example how the lawmakers reined in when something went wrong. And with this, I'm coming to the last part of my presentation. I wish to explore whether there are any patterns, whether there's anything that allows us to predict how things will develop in the future. I think from what I have discussed today, I can come up with four observations. And I think these are interesting observations. First of all, I think, as I had discussed, I think apart from China's WTO accession, it's rather difficult to identify specific events or factors which have triggered specific legislative activities in the area of investment law. Second, one can, I believe, nevertheless, observe a constant development of China's investment law system since 1979. I've mentioned many times this development was not based on a coherent approach. There was no systematic approach which followed an overall strategy. It rather appears that, as in other fields of Chinese law, legislators developed Chinese investment law in an ad hoc manner to support China's economic and political system at its various reform stages in line with political and macroeconomic goals. And this has led to the fragmented and very complex piecemeal framework, which underwent numerous changes to respond to different legislative needs over time, as I have outlined it earlier. Third, as I had mentioned, the building of China's investment law system was necessary to bring foreign investments to China to allow China to get access to hard currency and to advanced technology to support the reforms. It's very interesting that the creation of the underlying legal framework and thus the creation of legal certainty for foreign investors was a tool to reach this goal, but apparently not a goal in the first place in its own right. Fourth, since the start of the reform process in China in late 1979, China's investment law system has always been subjected, has always subjected foreign investments to restrictions. And as mentioned, that has given rise to many complaints, criticism, and also practical problems, of course. The ongoing liberalization process, in particular during the last decade, has, and this is despite the international criticism, improved the situation significantly and has preliminarily peaked, I believe, with the enactment of the PRC Foreign Investment Law in 2020, on the 1st of January 2020. What does all this mean for the future? The question is whether the enactment of the PRC Foreign Investment Law in 2020 marks the beginning of the end of all those challenges foreign investors had to face in the past years, and which I've tried to highlight today, or if history will simply repeat itself. I just want to focus on two aspects: legal certainty and restrictions. Uncertainty has always been a major inherent feature of China's investment law system, and that is, everybody who has been in this area knows this. I trust, however, that that we must acknowledge that this is probably just something which the Western world regards as extremely unfortunate, and in contrast, for Chinese counterparts, it could just be a normal feature of the Chinese system. You have a quote here: Chinese companies, that was published in 2007, Chinese companies will always have a hard time understanding why foreign companies can't get comfortable with the uncertainties inherent in the rapidly evolving Chinese regulatory landscape. The national regulatory environment is a moving target, so it is important to find the most effective way to work together, if you are able to do that, if you're familiar with the system, because it's also a system. Restrictions. As for the restrictions imposed by Chinese inbound investment law, in 2019, the former Vice Premier Zhang Peiyan was quoted by the South China Morning Post as follows: "We should maintain a certain degree of restriction on foreign capital in key areas and sensitive industries to prevent international economic risks and to protect our national economic security. The more we open up, the more we need to safeguard our national economic security and our trade interests." And as I've mentioned earlier, similar considerations are, of course, now adopted around the world, as UNSTAD had told us. Now, again, I hope I have demonstrated today that despite much criticism, China's investment law system has seen much liberalization in particular in the most recent past. In particular, the national treatment promise of the PRC Foreign Investment Law is a welcome development that meets the demands of many years. And yet, it is still common perception in the West that the rationale behind China's investment law system, investment lawmaking, and the application of Chinese investment laws will rather remain along the lines of the Zhang Peiyan statement. The historical account of the development of China's investment law system that I have attempted today over the past 4 decades is, of course, on the one hand, not able to dispel these doubts. But I believe that the notable liberalization trend over over the years is, on the other hand, remarkable and gives rise to hope that there is more to come, and that China's investment law system will continue to develop and provide improvements, an improved framework for foreign inbound investments. And with this, I will stop. Thank you very much for your attention.
Thank you very much, Lutz. Thank you very much for that in-depth consideration of China's inbound investment law. We've had a number of questions that have come in, and of course you finished things just on correct time. We've got a few minutes left for some questions. One of the first that came in sort of links into what's just been happening and what may happen in the future. From Shmuel Yerushalmi, he's asked, what are the opportunities that have been created by the COVID-19 pandemic for development and growth investment vehicles and investment drivers in China's economy? Do you think this is
that's a very good question. And in fact, it's not a question, I believe, which is China specific. COVID-19 has, of course, changed the world. And all over the world, we see developments, we see different, not only legislative developments. I've mentioned earlier the national security systems, which are enhanced, which are reinforced across the world. Previously, after 2008, 2009, this was, of course, in reaction to the global financial crisis, when economies had problems and they tried to then protect domestic industries. Now COVID-19 creates a similar situation, and UNSTAD has very clearly spelled out that COVID-19 will lead and has led to more restrictions throughout the world in terms of inbound investments. I haven't seen that in China. China has not imposed more restrictions, of course, apart from the quarantine rules and the lockdowns and all those measures. But specifically on the investment law system, I have not seen any new developments which are related to COVID-19. Of course, COVID-19 will lead to opportunities, to different approaches throughout the world in relation to investments in China and elsewhere.
Thank you. Another question that's come in is, why was China's M&A framework established so late?
That's a good question. Thank you very much. I mentioned earlier that China's inbound investment system was built on the Greenfield project, Greenfield model, that you create, investors create projects from scratch. Now, in the very early days, of course, M&A was not an option because there were no suitable targets for foreign inbound investors. Another aspect which may have led China to delay the introduction of M&A options was stability. If you have the option to for investors to move and to sell equity interests, to dispose of investments, then that may lead to some kind of movement in the market, and that's not what China needed, in particular in the early days. And of course, investments in state-owned enterprises was something which by foreigners was something which in the beginning was not, or was regarded, I should say, with suspicion. And finally, China wanted to support the reforms. And there is this assumption that when you go for a greenfield project, capital comes in, technology comes in, and all this helps to boost the domestic economy. When you think about an acquisition, you have an existing company which is acquired by a foreign investor. The perception could be that nothing has changed on the ground. It's just ownership which changes. And from that angle, of course, it doesn't appear to be all that interesting as a tool. Acquisitions do not seem to be interesting as tools to support the economic reforms. Having said that, of course, there are studies which show that acquisitions do support or are beneficial for the domestic industries. in the very same way like greenfield investments, because investors who come through the M&A routes, they bring in capital and they bring in technology, because what normally happens is, of course, you go in and you restructure, and that's for that purpose you use your own technology, you use your own financing in order to help.
Thank you. Let me just read the next question, which has come in. The PRC authorities seem to have taken various steps to tighten the use of SPVs in respect of inbound investments. Do you think the use of SPVs will be further restricted under PRC investment law?
Good question. Not only China, but also other jurisdictions have restricted the use of SPVs, SPV structures. In a way, I must admit that I once published an article where I said that SPVs are not per se something evil, because they can help in certain situations. They can be quite beneficial. But of course, SPVs have been used, and I have outlined that for illegal purposes, and they are globally used for holding structures in general for illegal purposes. The developments that I mentioned earlier in relation to round tripping saw transparency rules being put in place, and there's also a tax component that was added. When you sell your shares offshore, you may be taxable in mainland China, and other rules that are particularly linked to specific structures used by inbound investors in industries which are prohibited for foreign investments, so-called VIE structures. This is something which has not been finally decided yet. Everybody expected that the PRC Foreign Investment Law would address that issue expressly, but since these restrictions would also hurt Chinese round-tripping, Chinese investors who use round-tripping structures, reinvestments, a final decision has not been taken yet. I believe that in due course, this is going to happen. It will either go one side or the other, and I think the Chinese lawmakers will restrict these options further. But again, this has happened in the past. We have seen similar developments in the past, and the investors and their advisors are always one step ahead of the regulators, and we will see what new developments we will be able to observe.
Okay, thank you. We had some other questions linked into the VIEs and others as well, but we're running out of time, I'm afraid. So we'll save the chat for you for later so you can actually see some of these questions. A number of questions linked in, but I think possibly I can give you as the final question. You mentioned the international influence on the development of China's investment law system. What was the influence of international law firms and international lawyers?
That's a great question as well. Thank you very much. Of course, international lawyers, I believe, have had great influence. I mentioned earlier the involvement in lobbying activities, in comments and advice. That, of course, was very helpful. But I think most importantly, foreign lawyers have helped developing this whole process through their collaboration with domestic partners, with the authorities. It was a process of knowledge transfer where foreign investors dealt with these issues and allowed their Chinese counterparts to get that kind of experience, which these lawyers, of course, had from other jurisdictions. So I think, in particular, in the 1980s and the 1990s, the influence of foreign law firms and foreign lawyers was immense. And of course, they have also partly advised on development aid projects. They have advised, they have worked with Chinese government authorities. So I think a lot has been done in this regard, and there was really some good input from law firms and international lawyers.
Thank you all for joining us today for the last in the present series of the Greater China Legal History seminars. We will be back in September. We've already got an outline of our speakers for next year, and it's looking like being another exciting year with some great seminars organized. So we look forward to seeing you again there. Thank you for giving up your lunchtime and joining us. Feel free to join us for our future events. And thank you again to Professor Wolff for giving us such a great seminar to end this present series with. Thank you very much to everyone, and including our support staff as well, to Jay and to Ellen for supporting us today so ably. All that remains to be said is we are CUHK Law. Bye-bye.